This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the Fifth Amendment and the fact that it applies in any court, including a civil court where a drunk driver may have injured the plaintiffs, because the Fifth Amendment not only protects the drunk driver, but it also protects the bars where he drank if he refuses to testify about those bars. Plaintiffs sued Taylor Brock Peters for injuries they sustained when his vehicle rear-ended theirs. Peters was also charged with the crime of intoxication assault in the state of Texas. During discovery, the trial court ordered Peters to identify the bars that had served him alcohol, rejecting his assertion of the Fifth Amendment privilege against self-incrimination. Peters took the issue to the Supreme Court of Texas to protect his Fifth Amendment right against self-incrimination in a case entitled In Re Taylor Brock Peters, Relator, a decision of the Supreme Court of Texas on October 4, 2024. The facts of the case started when Austin police received multiple 911 calls about a crash on the I-35 service road. When officers arrived on scene, they found that a Toyota Tacoma driven by Peters had crashed into the back of a Toyota 4Runner occupied by two brothers, Constantino Palma Jr. and E.P., a minor, while the 4Runner was stopped at a red light. Peters' vehicle struck theirs with such force that the 4Runner's tailgate was shoved through the cargo compartment into the second-row seating area. The Palmas were transported to a hospital where they were treated for multiple fractures and internal injuries. EP was even intubated and treated for a skull fracture and brain hemorrhage. Peters was also admitted to a hospital, and shortly after his arrival, Officer Andrew Upton found Peters in his room, confined to a hospital bed with facial swelling and a bandaged forehead. His clothes were soiled and his eyes bloodshot. Peters told Upton that he had been at two bars whose names he could not remember, that he drank only 3 beers, and that he remembered being buzzed and then trying to drive home. Upton administered a preliminary breath test which showed that Peters had a blood alcohol concentration of 0.196. Peters was arrested and charged with 2 counts of intoxication assault with a motor vehicle, since his blood alcohol level was so far above the 0.08 minimum. A civil suit followed with the Palmas, who sued Peters for negligence and gross negligence. The Palmas sought names of the bars that had served Peters alcohol in order to initiate a timely dram shop action. Peters refused to provide information and invoked his Fifth Amendment rights. The trial court granted the Palmas' motion to compel, and the Court of Appeals denied Peters' mandamus relief, who then brought it to the Texas Supreme Court. The court, analyzing the issues, noted that the Fifth Amendment states that, quote, "No person shall be compelled in any criminal case to be a witness against himself," close quote. The privilege against self-incrimination applies not only to criminal cases, but testimony that could directly incriminate a witness or furnish an evidentiary link that might tend to incriminate him. The trial court must be satisfied, however, that the witness's refusal to answer is based upon his good faith and is justifiable under all the circumstances. The Palmas, on the other hand, contended that the assertion of the privilege interferes with the working of the civil justice system. The answers they seek were critical, they argued, because Peter's silence effectively bars their potential dram shop action. In Texas, a valid assertion of the privilege prevails, however, over the civil justice system's needs. The Supreme Court concluded that compelling Peter's answers could furnish a link in the chain of proof that might tend to incriminate him. Peter's fears that he compelled responses might be used against him in a criminal case are not imaginary. The state of Texas is prosecuting him on the very same facts that underlie the civil case. Courts should be loath to second-guess the privilege's application. The Palmases argue that even if the privilege would otherwise apply, Peters waived it by disclosing to Officer Upton that he had visited 2 bars, drank 3 beers, and felt buzzed. Upton's arrest affidavit, however, noted that Peters was confused and disoriented. It states that Upton interrogated Peters while he was confined to a hospital bed with a cut on his forehead that was causing swelling around his face. Peters faces a reasonable danger, according to the Supreme Court, of incrimination from disclosing his whereabouts before the collision. The Supreme Court conditionally, therefore, granted mandamus relief and directed the trial court to vacate the part of its order granting the motion to compel, and to then deny the motion as to those interrogatories. In my opinion, everyone facing a criminal charge in the United States may not be compelled to be a witness against himself. Telling the plaintiff in a civil suit the bars where he consumed alcohol before the accident would allow both the plaintiffs in the civil suit and the prosecutors in the criminal action to establish how much alcohol he consumed at each bar, and that his statements about what few beers he drank was false. The plaintiff may find a civil dram shop act against him, and the state will have the opportunity to prove the crimes for which he was charged, since they will not be able to use at a criminal charge his confused statements made to the officer, which was probably not made willingly or knowing with appropriate notice of the hazards of giving such information to the police department. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll gain access to the more than 4,900 blog postings. You can also subscribe to the videos on YouTube and rumble.com, and if you do, I'd appreciate a like button being clicked on at YouTube or a thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a small fee, subscribing to my Substack publication. Thank you for your attention.